The camera is on and the microphone is on. It is recording and being live streamed on YouTube as we speak. But obviously that article will start hopefully right. Thank you.
Thank you.
Thank you.
Yes. As you can tell, some of them
No need to stand. Thank you. Appreciate it, though.
All rise. The Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
You may be seated. You hit the red dot on the line. I want to welcome you to the 10th Court of Appeals oral argument today. We have one case on the docket. If there's anything that we need to talk about, if you're going to use exhibits or if there's anything like that that has been presented to the other side where there may be questions, we need to know it. We can give you your announcement. I don't think I need that microphone, so I'm going to turn that off. Can y'all still hear me okay?
Yes, Your Honor.
All right. The case on the docket is and I may mispronounce it, but I pronounce it Rezac.
Yes, yes, Your Honor.
Okay, Rezac versus Navarro College, 1021-00070 CV. I'll take announcement from the appellant.
Good morning, Your Honors. Lacey Most for appellant Cody Rezac.
Thank you, counsel, and for the college.
Good morning, Justices. Oleg Noodleman on behalf of FLE Navarro College.
Time is 20 to argue, 5 minutes for rebuttal for you. And please make sure that your phones are in the off or silent position. And we do allow folks to move around during the oral argument. It's all staff. And so although I think it's one of our court reporters from downstairs. So good to have you today. And so if there is, movement, we ask that they do it where it doesn't bother y'all, but just continue with your argument in that case. Gentlemen, anything before we get started?
Nope.
Counsel, you may proceed.
Thank you. Good morning. May it please the court. This case arises from Navarro College's employee using a fire truck's hose to shoot water at Mr. Rezac's head, bursting Mr. Rezac's eardrum, and which required surgery to repair. The issue before this court is whether the junior college district's employees' active use of a motor vehicle part waives Navarro College's immunity under the Texas Tort Claims Act. This court should reverse the trial court's grant of appellee's plea to the jurisdiction for 3 principal reasons. First, the most on-point case from a sister circuit is El Paso Independent School District v. Apodaca, which held that the active use of a motor vehicle's part waives immunity. Second, the trial court abused its discretion in granting the plea without jurisdictional discovery. Plaintiff had no opportunity to obtain complete evidence that would allow the plaintiff to controvert Navarro College's evidence attached to its plea, and the majority of cases cited by both parties allowed for discovery prior to ruling on a plea to the jurisdiction. And third, Mr. Rezac's affidavit raised a genuine issue of material fact as to whether the engine was on. While that is not required under El Paso Independent School District v. Apodaca, if the engine is on, it is in affecting the water pressure at the time of the incident, it is clearly waived under immunity is clearly waived. Your Honor, El Paso Independent School District v. Apodaca was from 2009, and in this holding, the court in determining the standard and what needed to be decided to see if jurisdiction is applicable, the court stated the injury happened as a result of an affirmative action by a district employee arising from the operation of a part of a motor vehicle. And in that case, Your Honor, the employee was raising a wheelchair lift that was misaligned, and the student in a wheelchair fell off and was injured as a result of that. The court stated that whether the engine is on is a factor that courts can consider in determining if use qualifies as use of a motor vehicle, but that it was not determinative. Rather, it focused on the fact that the school's employee had active use of the equipment or part of the motor vehicle. Notably, in determining its standard, the court did not just said whether it arose from the operation of a part of the motor vehicle. The court did not go into whether it mattered if the wheelchair lift was permanent or whether it was a removable part. The only mention of permanent in that case, Your Honor, was in the court's recounting of the appellant's of the student's argument to the court. And significantly also, this case and other cases look at the vehicle's function as a whole. Many of these cases involve school buses, and the courts have considered the overall use and function of the school bus, that is to transport students to and from school to their homes or the designated drop-off location, and has found that even after the student is off the bus, if an employee is actively using a component of the bus, that will allow the court to have jurisdiction so long as it's part of the process of getting the student safely to their designated location. And in general, Your Honors, the courts have been reluctant to permit government entities to isolate vehicle parts from the vehicle as a whole in an attempt to avoid potential liability and retain immunity. If we look through, there are several cases where this has come up. For example, Grand Prairie Independent School District v. Castro, where a student was injured by an exposed fan blade. There, the school district tried to argue that the fan is separate from the engine and separate from the vehicle, but the court still held that was a part of the vehicle. And similarly, in within ISD versus Ziegler, this is the tractor case where the tractor was the motor vehicle, but the injury was caused by the auger that was attached to it. Similarly, in Ryder Integrated Logistics v. Fayette County, there was an argument posed by the county that the operation of headlights alone does not qualify as use of a motor vehicle. And in that case, also, the police officer was in the process of relocating the vehicle and repositioning it. But overall, courts have seemed less inclined to allow school districts to part and piece vehicle components from the vehicle as a whole. The few cases, one of the recent cases that did allow that was a South v. Cedar Creek municipality utility district. And we can distinguish that case based on the fact that it was it was city liability under the theory of motor powered equipment as opposed to a motor vehicle. Motor powered equipment is a more ambiguous term. And in that case, it involved the function of a sewage system. Some isolations of components may be more appropriate in that case because we could technically, if we said the entire sewage system was a motor vehicle or motor powered equipment, that would probably extend beyond the intention of the legislature. And also this case came out before the Rattray case from the Texas Supreme Court. And depending on when, with the benefit of the Rattray case, that court might have, the court in the Selby Cedar Creek municipalities may have come to a different result, simply because Rattray clarifies that it is not a necessity that the engine be active at the precise moment of injury, but rather allows the court to look at it as a whole. So if the manipulation of some other product or engine or motor powered equipment happened a bit before, but still as part of the episode, it could still likely qualify as a waiver of immunity.
What was the style of the Cedar Creek case that you mentioned?
The Cedar Creek Municipality Utility District. And that was out of Tyler. And it is an unpublished opinion.
How does the general I guess you'd say philosophy is expressed as recently in the Rattray, I would have said Rattray, but I'll go with the Rattray.
I wasn't sure how to pronounce it.
But that we construe the waiver narrowly, that the presumption is against a waiver, and that a waiver has to be clear and unambiguous. And how does that factor into what we're doing here?
Your Honor, I believe that has been consistent with the law since we've had immunity under the Texas Tort Claims Act. It has always been an narrow interpretation relying on the legislature's definition. Your Honor, something in particular in this case, the claim is for negligent use of a motor vehicle. The legislature has decided to use the term motor vehicle as opposed to school bus or something more defined, more limited. A fire truck is a motor vehicle, and so it should still fall under that category. And these prior cases that addressed extending it to parts of the motor vehicle, including the Apodaca case, which extended it to parts regardless of if the motor is on, allowing that to be a factor but not determinative. That case was decided in 2009. The legislature has had the opportunity to adjust that if it saw it appropriate to, but has declined to do so.
Well, the reason I asked and circle back to the Cedar Creek case, you talked about it being in connection with a sewage system. There was another case involving the sewage system where it was held that a pump driven by an electric motor was motor driven equipment. And that becomes really important in this case in light of the fact that there is, I'll just say, so much attention being put on the pump that is on the fire truck, and that then shifting to the Ryder case where we talk about, or where the court talks about, Supreme Court talks about the fact that it's got to be being used as a vehicle. And it seems to me that the use of the fire truck as a vehicle had ceased, and then you've got a pump that has been connected to a fire hydrant. How would you address that argument?
Your Honor, first, there's a factual dispute in this case that appellant's ability to fully challenge is limited by discovery. I believe there is additional discovery that would allow us to fully controvert whether the engine was on at the time. And regardless,
Let us assume that it was, so that part and the need for discovery on that is taken out of this discussion that you and I are having right now. How does that affect the analysis? Because I can tell you, and it's not because I'm clairvoyant, it's because I read his brief. I know he's going to get up there and say a van parked on the side of the road is clearly a motor vehicle. And it was left on the side of the road and it was determined not to be liability in the context of a Tort Claims Act waiver. So see if you can weld those together for me.
yes, Your Honor. In terms of the van parked on the side case, there was no dispute that it was a motor vehicle. The dispute in that case and the issue that led to the holding in that was the lack of active use or operation by an employee of the school of the entity. Whereas the court noted that the employee had simply parked on the side of the road and left to go inside, and that it was a third-party vehicle that crashed into this vehicle, the van at issue, and caused the injuries. In general, the cases that we have been cited regarding situations where where courts have found that there was not active use, there was not negligent use or operation of a motor vehicle, turn on whether the employee was actively using a component of the motor vehicle or of the motor powered equipment versus the incident was caused by the plaintiff's own negligence, by a third party's negligence, or was merely setting of the incident. So, Your Honor, because there's no dispute that the van is a motor vehicle, and similarly, there's no dispute that the fire truck, at least in part, is a motor vehicle. And what the courts have relied on, what the courts have turned on, is the employee's action in using that motor vehicle, as opposed to saying that it ceases to be a motor vehicle.
Okay. The briefing focused a lot, and the affidavits in particular of the college, that the almond who opened the hose, the nozzle, he never drove it, he never operated a PTO on it, he was at the end of I'll just say very long hose, holding a nozzle, essentially very far removed from the use or operation of a motor vehicle. How do you respond to that argument?
He was still operating a component of the motor vehicle. The Texas Tort Claims Act does not require that the negligent use or operation be by the driver of the vehicle. It simply requires that an employee had negligent use or operation of a component of that vehicle.
Do you think it makes a difference? I mean, there are general use motor vehicles and there are specific use motor vehicles, like the tractor situation or a school bus, or in this case, a fire truck, versus just a like the van, just a general use type deal. It's designed for transporting people. Fire truck's designed for transporting the firemen and hooking up hoses to it, spraying water out of it, and fighting fires. Does that make a difference in your analysis?
Yes, Your Honor. Prior cases, which are mostly school bus cases, focus on the purpose and role of the school bus, and that analysis should also be applied to the fire truck, because it is well known that a fire truck's purpose, in addition to transporting, is to also allow firefighters to shoot water generally at a fire. But this is an expected action and contemplated with the use of a fire truck. And since the courts have considered use and purpose with school buses, courts should also consider the use and purpose with the fire truck.
You know, I'm going to ask this question: where was the fire?
Your Honor, it was at a burn field, and just because,
I'm being facetious,
Oh,
because
okay.
obviously there wasn't a fire.
yes, Your Honor.
And so, you know, when we start down a road, it's always useful to see where it will take us. And, is that important that they were or were not fighting the fire, as opposed to, some people would say hazing a bunch of graduates?
Your Honor, it's not important that it had to do with that there was no fire at the time. For one, this was even if it was at the end, it was part of a training demonstration. So it was part of a function that we would expect a fire truck to be used, especially at a school with a firefighter training program. And I believe that the negligent use component in Texas Tort Claims Act contemplates that something might not be used for the direct or typical use we might expect, and that could still be encompassed. Often something that is negligent involves someone doing something that they were, and not the way that it is entirely meant to be used.
Does it matter to you and your analysis that once the I mean, because a lot of the cases in talking about a motor vehicle, it talks about being self-propelled, and that once this vehicle was attached to the fire hydrant, it could no longer be propelled without, I guess, tearing up the system, if you will. You know, because it's at that point it's somewhat anchored.
Your Honor, I believe Your Honor, I don't believe that it makes a change to it necessarily, especially when we consider additional factual issues that we sought discovery on and amend leave to amend, Your Honor. In particular, and coming back to the Rattray case, and what was presented at the trial court and discussed, it's a possibility that the pump, because it was still going through the fire truck, even if it was the hydrant pressure, that there could have been residual pressure or force from that recent use of the engine, assuming if that would affect the pressure, similar to how if there's a clog in a pipe, sometimes once that gets loose or gets pressure, that initial burst is much stronger than what you may expect. For that reason, Your Honor, just having it connected to the hydrant, I don't believe negates it as a motor vehicle, because
If you were allowed additional discovery, they've complained that it is broad, unending. What is your response to the scope of discovery that you should have been allowed?
we should have been allowed targeted jurisdictional discovery. In particular, this was an event with family members and friends present who are disinterested witnesses. The appellee's affidavits discuss that the fire engine was very loud, so it should be apparent to those witnesses whether the engine was on at the time. They could also possibly testify to whether one of the jets of water that was shot at the students appeared to be stronger than the others, which would also go to the water pressure. And also discovery into exactly how the pump on the fire truck works, and if with recent use, if that could still have an impact on water pressure following.
Yeah.
And Your Honor, I would just we believe that discovery is an important issue here. Defendants have submitted affidavits, factual affidavits, and plaintiff did not have a meaningful way to controvert them. And that discovery would allow that opportunity. And I see that my time is up, Your Honor.
I'm trying to remember, you had 3 fundamental issues, discovery, and I forget what the third one was, continuance. Would you address the continuance issue?
Continuance of the plea to the jurisdiction decision.
Yeah, I wasn't clear if that was only for discovery or if there was something else related to the continuance.
There was also a request for leave to amend to add into our petition to more explicitly address the residual pressure issue.
Okay. All right. Thank you, Council. You'll have 5 minutes for rebuttal.
Great, thank you.
Council, you may proceed when ready.
Good morning again, justices, and may it please the court. As Mr. Rezac alleged in his amended petition, which he filed after we filed our plea and the day before the oral argument on the plea to jurisdiction in the trial court, he alleged, quote, that the force of the water, end quote, ruptured his eardrum. The trial court correctly determined that it did not have subject matter jurisdiction in this case because use or operation of a motor vehicle did not cause that injury. Mr. Rezac was hurt when an employee standing 100 feet away from a fire truck sprayed water at a fire hydrant, derived pressure from a fire hose at a group of students. Immunity was not waived because use or operation of a vehicle did not cause the injury. And we know that because the fire engine could not, even though it was on the site at the time, could have been parked in another town miles away, and the hose could have been connected directly to a fire hydrant, and the same thing would have happened. The same water at the same pressure would have traveled from the hose to from the Mr. Allman was holding, and the same thing would have occurred. The fire truck didn't need to be there. It did not make any difference, and its operation didn't cause the injury.
Why is that not like in Rattray where the court said, we're not deciding that you have jurisdiction, but we're deciding that this is not the basis of not having jurisdiction by whether or not the rainstorm caused the flood that caused the damage?
Thank you. Thank you for that question, Your Honor. In Rattray, what the court, as we understand it, what the Supreme Court held was that, again, they reaffirmed the importance of that arises from causation requirement. There was motor-driven equipment, the gate in the Rezac, if I'm pronouncing that correctly. Here it's motor vehicle. We submit that the analysis is really the same. And what the court there held was that if the same storm could have happened without the flooding, and it was the use or operation of that motorized gate that made the difference, then the causation requirement under the Tort Claims Act is satisfied. That is not this case, justices, because the same spraying could have happened without without the involvement of the fire truck, and the use of that truck didn't make any difference. The water merely passed through it. This is, I think, that quintessential.
We understand that's your theory,
Yes,
but
sir.
there's at least some suggestion in the evidence that the motor was running on the truck and that it would have increased the pressure if the pump was running and if the pump had been engaged. And so why does he not get to trial? Why does he not get to try that?
Your Honor, he doesn't get to trial because the competent jurisdictional evidence that was presented to the trial court was correctly analyzed by the trial judge, and the competent evidence presented by the declarations of trained firefighters who are also instructors who are licensed by the state. Each of their declarations explains in detail how fire trucks work, what exactly happened on the night of the family night, both earlier in the night during the demonstration of actual firefighting, and later during this group picture where they were sprayed with water at hydrant pressure. The competent evidence showed that there was no use or operation and that the pump was not on.
But
Well,
the others, go ahead.
Well, I'm just going to say, you
Yes, sir.
earlier said that, at least from what I understood, that the water pressure coming out of a hydrant, you don't need the truck, and it would be the same. Well, it seems to me that there's a fact question about if that were the case, why would you ever hook up a hose to a fire truck? Number one. And number two, you keep talking about competent evidence before the court. What about competent evidence that wasn't there because the judge did not permit discovery?
Well, Your Honor, the judge's decision to not permit discovery was appropriate because the evidence that the evidence that we presented negated the issue of jurisdiction. And we submit that it was not an abuse of discretion for the court to, it was certainly not clear error for the court to not order additional discovery, given that the information that was before the court was clear on the key question: is spraying water from a hose use or operation of a vehicle? And in this case, everything that was before the court that was competent, that wasn't conclusory, showed that there was no operation of the truck at the time. If you look at the cases that the appellants cited, Your Honors, all the cases that are analogous to this, that involve attachments to vehicles, that courts of appeals have previously considered, in all of them, the real issue was, what did the vehicle do? If you look at Vidor v. Benson, I think Vidor ISD v. Benson, I think one of the ones that we cite in our brief and discuss. That was the one where there was a rope attached to the back of a truck and they were pulling, I think, a table, and somebody got entangled in the rope and injured. The issue wasn't decided just on the fact that the rope was attached to the truck. The case was decided because the vehicle pulled on it. The court actually said the rope as an inanimate object was incapable of inflicting this injury without the aid of the force acting on it that was coming from the vehicle. The Lipan ISD versus Bigler case, the one with the auger attached to the back of a tractor that Ms. Most mentioned. Again, same idea. The auger was incapable of causing the injury without force coming from the tractor. And in Ray, the same thing. The court said the vehicle, the motorized item must make a difference. Grand Prairie ISD versus Castro, another case they brought up where immunity was waived. Operation or use must actually, that was the one with the fan under somebody's seat. Operation or use must actually be a causative factor, and absent the motor's power, there wouldn't have been an injury. So again, you look at it as if you take the fire truck out, the operation or use of the truck must make a difference, and here it wouldn't. And actually, if I may, I'd like to come back to that self versus what is the water called? West Cedar Creek Municipal Utility District case from Tyler Court of Appeals that we cite in our brief from 2021 that Ms. Most also raised, because I actually think it's very instructive. Now, that was about a sewer system that had multiple parts, including one motorized component, the pump, and then a bunch of valves, connectors, and such. And it was a connector that failed. And what the plaintiff in that case tried to argue was that, well, it's all one thing. The connector is, quote, part and parcel of the motorized system. The court looked at this closely and determined, well, no, the motorized part didn't fail. The coupler, the connector piece failed. Therefore, there was no waiver of immunity. And here, justices, there was, again, there's correctly decided in the trial court that there was no waiver of immunity because the fire engine was off. It was not in use or operation. That is what the competent jurisdiction of
What about the question of the residual pressure on the hose?
Your Honors, there is absolutely no evidence whatsoever about residual pressure, and our declarations actually negate that entire idea because they show.
Isn't that the point of them needing additional discovery to develop that?
Well, respectfully, Your Honor, I disagree because they had the opportunity to put forth allegations that the court must consider as the Supreme Court has held at the earliest opportunity to determine whether additional discovery is necessary. That entire residual pressure idea came from a hypothetical question that the judge asked both of us during oral argument. It wasn't actually anything that anybody believed based on any facts that was involved in this case. And our declarations, which show that the engine was off, that the motor was off, that it wasn't affecting the passage of the water.
So you're saying that the residual pressure was never pled or evidence produced on that point. Is that correct?
Yes, Your Honor, both of those things are exactly correct.
Because I mean, with the plea to the jurisdiction,
Excuse me.
all the plaintiff has to do is plead or produce evidence. There's no necessarily burden on them. But they do have to plead and prove, or not prove, excuse me, plead and produce evidence. And you're saying that you're that some of that was that their evidence was lacking, and you had evidence that conclusively established otherwise. Is that the record of, and I'm just trying to pick up on where your argument's going.
That's exactly right, Your Honor. And I respectfully just want to emphasize a little bit that I think there is a burden on the plaintiff under the case of law from the Texas Supreme Court. I think it was the Miranda case where they said, well, you can't get past a plea to jurisdiction just by talismanic allegations. You have to have the whole purpose of the jurisdictional plea system is to allow a governmental entity to put forth an evidentiary argument, potentially in an early stage of the case, to show why this is not why immunity has not been waived, so taxpayer resources don't have to be.
And I don't disagree with that, but
Yeah.
I'm talking about situations where plaintiff produces one set of facts, you produce another set of facts. If there's a conflict, the trial court can't grant the plea at that point in time.
Respectfully, Your Honor, I think if you look at the cases that we cite, the court doesn't just say, well, there is a conflict and we can't grant it. If you look at the Self case, for example, the plaintiff in that case actually had an expert witness put forth a declaration. I think it was an expert licensed plumber who was actually saying, oh, you know what, actually, I think the pump in the sewer system was in operation and was pressurizing the sewage tank or whatever it was. But the court, what did the court do? The court looked at the evidence before it and determined that under the circumstances in that case, that even though the plaintiff had an expert, that was no more than a mere scintilla of evidence. It was not enough to create any kind of issue, because I'm trying to find the direct quote here, because the courts must ignore assertions that are so slight as to make any inference a guess. And what was presented in this case by the appellant was merely suppositions and conclusory allegations. Well, the only source of pressure at the thing was the fire truck. Well, no, respectfully, that's ridiculous. We all know fire hydrants create pressure. He alleged that he could tell that the pressure of the water was the same as during firefighting, but he wasn't hit with water then.
Respectfully, what he said in item 8 was, to my knowledge, the only water pump at this location was the pump operated via the fire truck engine. And I've got to ask, I mean, this guy just finished your school, and how is he not qualified to testify about firefighting, water pressure, and the size of fire hoses?
Well, respectfully, Your Honor, what the court was presented was a declaration from him. He did finish one semester in our fire school, but there was no foundation presented about his knowledge of firefighting equipment in general, firefighting equipment at the site. We don't know how often he had ever been there before, if he had ever even been there.
But he had just finished your school. He says that in his affidavit. He was there as a graduate. I mean, he had been using this very hose, according to his affidavit. He'd been using this very hose earlier in the evening.
Yes, sir, but he was holding the hose at a completely different event. And that event was pressurized firefighting. The whole point of the pump inside the fire engine.
And he testified that the pressure was the same while he was holding it versus when he got sprayed with it.
Well, We believe that that was just basically completely unfounded and conclusory, and we explained that in our briefing to the trial court, which granted our objection to that statement. He wasn't hit with water earlier, and he wasn't holding the hose later during the spring. So how can he compare the pressure by feel, I guess, during those two completely different times of that evening?
Well, counsel,
Yes, Your Honor.
the Tort Claims Act is to protect the state. And I understand that there's a way for them to get out of it through a pleading jurisdiction. Assuming conversely, that a plaintiff has a right to try to get around that. How do you respond to the fact that they sought the opportunity to replead, maybe to talk about what Justice Johnson was talking about, some additional facts? And the trial judge not only denied discovery, but denied the right to replead.
Your Honor, I appreciate that question. The reason why the right to replead was not required here is because our evidence already negated the amendment that they were going to put forward, which was the speculation about, well, there was residual force from earlier, again, just based on a hypothetical.
Well, how do you know what they were going to replead if they didn't replead?
Well, they specifically stated it, including in their motion for new trial, after the plea was granted, what they were going to say. They were basically going to adopt the hypothetical from the judge that, well, there was residual force. Our declaration specifically stated that there was not that because the engine was off and there was no pressure coming out. And also,
we understand their argument, there was a fact question as to whether or not the engine was on or off.
That is their allegation, Your Honor, and that's correct. However, under the case law that covers pleas to jurisdiction, courts may receive evidence and consider it, and it's almost like on summary judgment. Just mere allegation and to say, well, I think it was on is not enough. Mr. Rezac was at the scene. He doesn't say, oh, I saw somebody in the truck. I heard from somebody that it was on. He doesn't say any of that. It's all speculative, and the trial court correctly analyzed it, and it did not abuse its discretion in striking those conclusory statements. And also, just to add one thing on the amendment point, the appellant did amend once already. They amended after we filed the plea. If you look at the Supreme Court's decision in Harris County versus Sykes, if a plaintiff has been provided an opportunity to amend after a plea has been filed, and the plaintiff's amended pleading still does not allege facts that would constitute waiver of immunity, then they should dismiss the action. The day before the plea argument, he actually filed an amended petition saying, listen, I think the fire truck was on. So he already alleged that, and that was before the judge. The first thing I said when I got up before the trial court for the plea to jurisdiction argument was, yes, they filed a new pleading last night. It doesn't make any difference because the evidence we've presented negates the existence of jurisdiction to waive immunity. Just a couple more things as I wrap up, Your Honor, so please let me know if you have any other questions. Just on the point, the plaintiff has relied repeatedly on the Apodaca case. The Apodaca case is plainly distinguishable because that was about use or operation of a bus in terms of moving a student to exit the bus, which was part of the core operation of that bus. That case would be relevant if the employees could have used that wheelchair lift to injure the student in the same way, if you imagine the bus not being there. But that wouldn't have been possible because the whole point was that they basically they incorrectly moved the kid. Here, the same injury could have happened without any fire engine involvement. That means that the use or operation of the vehicle did not cause the injury. As you noted, Your Honor, earlier, immunity must be strictly construed. The court in Reg just recently reaffirmed that. If the vehicle is only the setting for the conduct or just furnishes the condition for it, then there is no waiver of immunity. And here, that's exactly it. The water just went right through, went from the hydrant through the truck to the hose. And that is not, we submit under the case law requiring waiver, limiting what waiver of immunity is under the Tort Claims Act. That is not a immunity waiver. Unless you all have any other questions. I think I'm supposed to wrap up in 8 seconds.
I guess a footnote on this would be that regardless of how negligent Mr. Allman may have been by this blast of water into Mr. Rezic's ear, that your position is that with or without the truck being in the line, the college has no liability for that.
That's correct, Your Honor, because the case law says that it's the use or operation of the motorized vehicle must be the difference maker. And it just wasn't. The fact that there was water coming from a hydrant into a hose through the truck, yes, but not in any way affected by the truck, did not affect the pressure and did not affect the force of the water that Mr. Rezac is complaining about. Thank you, Your Honor.
Thank you.
I appreciate the opportunity to be here.
Appreciate y'all coming to Waco. You may proceed when ready.
Great. Thank you, Your Honor.
Could you address the Sykes case that he mentioned?
Yes, Your Honor, let me here. I believe these sites, I'm sorry, I'm trying to.
And I made a note to address it, and right now I can't remember what it was about. But I remembered that I wanted you to address it in rebuttal.
Okay, so we,
I'm gonna turn to counsel. Counsel, what was the Sykes case about?
Honestly, Your Honor, I don't have the facts in front of me.
No, I mean, what was the legal principle that you cited
Oh,
Sykes for?
The legal principle that I cited Sykes for was that once somebody has had an opportunity to amend once after a plea to jurisdiction by governmental entity has been filed, you don't need to do it again.
Thank you. And I'll give you some more time at the end for his responding to my question, but go ahead.
I appreciate that, Your Honor. The rule is that leave to replead should be freely given if it will make a difference. And there are plenty of cases where somebody has pled their best case, and even if they replead, it's not going to make a difference. And that's simply not the situation here. We discussed the residual pressure issue. When that was brought up at trial court, it was brought up by the judge asking whether that was explicitly what we were pleading, whether that issue was before the court. And my response on that was, that is something we would plead, but we would also need to discovery to ensure it is a viable and reasonable claim. And so under those facts, leave to replead because it would make a difference, because if there is residual pressure that affected the water flow, there would be jurisdiction and immunity would be waived. And Your Honor, turning to this residual pressure issue, the affidavits submitted by the appellee did not address the possibility of residual pressure beyond a conclusory statement that the pump was no longer affecting it, but not explaining how it would, how they knew that or why that was the case. Your Honor, there was I also noticed there was a lot of discussion on competent evidence. And the cases cited where the parties cited to show what competent evidence entails, they had the opportunity for discovery. You see reference to expert reports, depositions of employees, and documentary evidence. And that is also true for the Cedar Creek municipality case. There were expert reports and there were also deposition testimony of employees of the utility system. So it seems unfair to be able to complain about the lack of competent evidence while one party has not had the opportunity to obtain more competent evidence to controvert affidavits that are presented. Your Honor, additionally, Your Honor, as to Mr. Rezic's affidavit, while we would obviously like to provide more to the court, his affidavit did enough to raise a genuine issue of material fact. Mr. Buchanan, who was an affiant for the appellee, noted that the reason they were spraying these students was to celebrate they are no longer students, but firefighters. That suggests that Mr. Rezac, as one of the former students, is now a firefighter and would be qualified to give his testimony on some of the issues. And in particular, Your Honor, there is also Mr. Allman's statement to Mr. Rezac following this incident that he didn't know the pressure was that high. The affidavits from appellees state that all the water sprayed was at relatively low hydrant pressure. If Mr. Allman has noticed that the pressure is higher than what he would expect from low hydrant pressure, then there's a reasonable inference that pump was on and in the truck and affecting the water flow. And Your Honor, also appellee brought up that the standard is similar to a motion for summary judgment. One of the most common reasons, or one of the reasons for not ruling on a summary judgment or denying or staying the ruling is for discovery to occur. It is exceedingly rare for a motion for summary judgment to be filed at the outset of the case prior to any discovery, especially when discovery has been served and the opposing party has requested discovery in the matter. And also on the El Paso Independent School District, the Apodaca, there's no debate that whether the motor is on is a factor. It simply states that it's not determinative. Your Honor, for the foregoing reasons, we ask that this court reverse the trial court's ruling and remand to the trial court. Plaintiff or appellant deserves the opportunity to discovery to fairly and fully develop his case, and under the most on-point case law, the current evidence what is before the court suggests that immunity has been waived. Thank you, Your Honor.
Thank you, counsel.
Thank you.
This case is submitted and y'all are excused. Thank you.
Thank you.
Thank you.